Hello students, welcome to class 1 Political Science class. Today I will continue lesson 6 Law. The topic is sources and kinds of law. The objectives of the lesson are law, its meaning and definition, nature of law, theories regarding the nature of law, sources of law and kinds of law. The objectives of the day are sources of law, kinds of law, and it covers your pages from 139 to 143. Before the discussion of these objectives, I would like to discuss the key terms with you. The first key term is religion and morality. The origin of Hindu law in India can be traced in the Code of Manu. Students, Manu is the term found in the various meanings in Hinduism. According to myth, Manu is the first man on earth like Adam in Christianity. Is it clear? Likewise, the origin of Mohammedan law can be traced in the Shariat. So, God is ultimate source of divine law and it is based on morality. So, religion and morality are correlated. Next is judicial decisions and law. Here, judicial decisions are correlated. During proceedings of case in courts, if there is any ambiguity in any particular law, the judge interprets it according to the legal requirements and thus creates a new rule. It becomes a court of record. In course of time, this new rule is recognized by state and it becomes a law. Next is ordinance. Ordinance is the law promulgated by the President of India on the recommendation of the Union Cabinet, which will have the same effect as an Act of Parliament. It can only be issued when Parliament is not in session. Students, you know, there are 3 sessions in a year, that is budget session, monsoon session and winter session. But ordinances are issued when there is no parliamentary session. It enables the Indian government to take immediate legislative action. Otherwise, there is a custom in India that every year on 26th January, our president issues an ordinance. Students, can you know that why this custom is there? Why president issues ordinances on 26th January? You must remember that our first president was appointed on 26 January 1950. Just to honor him, every year on 26 January, our president issues an ordinance and later it is approved by Parliament and it becomes an law, an act. Is it clear? Next is delegated legislation. Law that is not passed like an act of parliament but by a government minister, a delegated person or an entity in the United Kingdom. This is in United Kingdom. Under the Indian Constitution, the concept of delegated legislation was not mentioned specifically, but Article 312 empowers Rajya Sabha to create such power. Now the topic begins, sources and kinds of law. I will give you first introduction. Jurists like Austin define law as command of sovereign. He says law is a command of sovereign. This is just as if there is only one source of law. However, this is not the reality. The reality is that there are several sources of law. These can be described as given. The first source is customs and usages. Customs has been one of the oldest sources of law. In primitive societies, social relations gave rise to several usages, traditions, and customs. Established customs were used to settle and decide disputes among the people. Customs were practiced habitually, and violations of customs were even punished by society. The social institutions began working on the basis of established and accepted customs. Students, here I would like to share an example of Hindu marriage system. During marriage, there is a custom that boy and girl move around the fire, and then wedding is considered as it is completed. And this is a custom is accepted by our society also, because this custom of moving around the fire is done in the presence of senior members of the society. If this custom is done, they all accept that marriage is complete, and our courts also accept this custom. Otherwise, according to Western system, the wedding is complete if they register themselves in the court. But in India, we follow this custom in the case of wedding. So custom has become law. Gradually, the state emerged as the organized political institution of the people, having the responsibility to maintain peace, law, and order. Naturally, it also began acting by making and enforcing rules based upon customs and traditions. In fact, most of the laws had their birth when the state began converting the customs into authoritative and binding rules and values. Custom has been indeed a rich source of law. Just now I gave you an example of Hindu Marriage Act time. Now one more example I will give you. Students, here I would like to tell you that in case there is a dispute between two brothers over any issue, finally the elders settle the matter and they both touch the feet of elders, means they show their respect, and it means they finally compromised and accepted each other. Touching feet is a culture, it is a custom. Even some laws are based on such basis, such customs. Like if there is a misunderstanding between husband and wife, and the case is going on in the court for divorce, then if the husband wants to compromise, then he can file an application for the restitution of conjugal rights. In case of divorce, he can file this an application. Under this, the order by court, the wife is to go back to her husband's home, and she is to be there for some period, and maybe her family life gets settled, gets normal. Now, here, what the court has done normally, our elders also do the same in the family. This is our custom. to compromise with our family, to save our family. So this custom is followed by a court. This is the section 9 of Hindu Marriage Act based on our customs. So students, I can say you that customs are also a source of law. Is it clear? Next is religion and morality. Religion and religious codes appeared naturally in every society when humans began observing, enjoying, and fearing natural forces. Students fearing natural forces and then worshipping them out of fear. This factor we find in Indus Valley civilization also. That time also, it is guessed that people had fear of natural forces like sun, rain, water, and then they worshipped them as gods and goddesses. Students, in Hinduism, this is going on till today. Students, we worship water as Varun Devta, sun as Surya Devta. Till today we are worshipping. So this is religion as morality. This is law till today. Next is these were accepted as superior heavenly forces like gods and goddesses and were worshipped. Religion then started regulating the behavior of people. It compelled the people to accept and obey the religious codes. Several religions came forward to formulate and prescribe definite codes of conduct. The rules of morality also appeared in society. The religious and moral codes of society provided to the state the necessary material for regulating the actions of the people. The state converted several moral and religious rules into its laws. Hence, religion and morality have also been important sources of law. Next is statutory law. Students, you know England is known as mother of democracy and first parliament was formed in England in 1215. This way the democracy started there, but the lawmaking starts by the order of the king and afterwards legislature got recognition as lawmaking organ of the state. Traditionally, the state depended upon customs and the decrees of the king for regulating the behavior of the people. Later on, the legislature emerged as an organ of the government, engaged in transforming the customary rules into definite and enacted rules of behavior in society. The king, as a sovereign, started giving these his approval. Gradually, legislation became the chief source of lawmaking, and later on, legislature got recognition as the legal sovereign, that is, lawmaking organ of the state. In contemporary times, legislation through legislative body has become to be the most direct source of law. I know in India this is done by parliament consisting of two houses, that is Lok Sabha and Rajya Sabha. Now next is delegated legislation. Currently, delegated legislation too has appeared as a big source of law. However, the system of delegated legislation always works under the control and superior lawmaking power of the legislature. Moreover, when the legislature is not in session or when an emergency arises, the head of the state can issue ordinances which have the effect of law but only for a limited period. Students, you must be knowing who is the head of the state in India. That is the president. And what is a limited period? That is only the 6 weeks. Within 6 weeks of the next session, it must be approved by the legislature. Otherwise, it dies automatically. Such ordinances are either transformed into laws by the legislature or these get lapsed after particular period of time. Here, I would like to tell you that such delegated legislation or power to issue ordinances is also called backdoor entry. You know why? The reason is that Parliament is not in session, so it is issued. If such order comes through a bill in Parliament to be passed, naturally there would be big noise. You know who will make noise? That is opposition party. During the question hour, 0 hour, they will ask questions. To avoid such situation, it is introduced as an ordinance by the ruling party through president. But here I would like to tell you that such ordinance must be approved within 6 weeks of the next session. Is it clear? Normally, the ruling parties take disadvantage also of this ordinance. Next is judicial decisions. In contemporary times, judicial decisions have also emerged as an important source of law. It is the responsibility of the courts to interpret and apply a law to specific cases. The courts settle the disputes of the people in cases that come before them. The decisions of the courts are binding on the parties to the dispute. This also gets accepted as law for future cases, but not all judicial decisions are laws. Only the judicial decisions given by the apex court or the courts which stand recognized as the court of record, like the Supreme Court and the High Courts of India, are recognized as the laws. Here, I would like to tell you that Court of Record becomes the judgments of the High Courts and Supreme Courts only. The judgments of Supreme Court are followed throughout India because Supreme Court is the highest court of India, that is the apex court, and the judgments of the High Courts are followed in that state only. Like if Punjab and Haryana court give any judgment which becomes a court of record, that will be applicable only in the states of Punjab and Haryana. Is it clear? That can't be applied in any other state. Normally, while the judiciary judgments and hearing is going on, the lawyers give the reference of such cases during the hearing. Thus, law has several sources. However, in contemporary times, lawmaking by the legislature of the state continues to be the main source of law. So lawmaking is by the legislature is the main source. Otherwise, there are the many sources like by the judiciary, by the executive head, by through ordinances. So there are many sources. Otherwise, the main source is through the legislature. Next, I will discuss the kinds of law. Basically, the law is of two kinds, that is national law and international law. Obviously, national law is applicable within the country and international law is the law of the nations. National law is the body of rules which regulate the actions of the people in the state, and international law is the body of rules which guides and directs the behavior of the members of the community of nations. It is a law among the nations. Students, national law is applicable on the citizens and international law is applicable on the governments. Now I will tell you the kinds of national law. That is, first is constitutional law and second is parliamentary law. You know, constitutional law is the base, that is a guideline for the government, and parliamentary laws are going on, that is whatever law is made after the constitution came into being, that is called the parliamentary law. First, I will tell you about the constitutional law. Constitutional law is the supreme law of the land. It stands embodied in the constitution of the state. Constitutional law relates to the organization, powers, functions, and interrelationships of the three organs of the government, that is, legislature, executive, and judiciary. It also lays down the relationship between the people and the government as well as the rights, freedoms and duties of the government, of the citizens. It can be called the law of the laws. You know why it is called the law of the laws? Because all the laws are to be within the boundaries of the constitution. No law can be out of the limits of the constitution. If it goes beyond the constitution, it can be declared null and void by the court, that is the Supreme Court. Next is national law. It means the system of law of the state which is being enforced by the state through its law courts. It applies to all citizens and the whole territory of the state. It is a law established in a single country and applies to the people of the state. National law naturally are applicable to the people of the state. It is not applicable to any other country. It is applicable to only our own country. In contemporary times, the laws passed by the legislature of the state, implemented by the executive, and educated upon by the judiciary together constitute the system of national law. Students, here in this one line, I have talked about all the three organs of the government. That is, in contemporary times, the laws are passed by legislature, one organ, implemented by the executive, second organ, and educated upon by the judiciary, third organ. Is it clear? So, in the laws, all the three organs are involved. Next is statutory laws. The laws enacted by the legislature of each state are called statutory laws. These are passed by the legislature in accordance with the powers given to it by the constitution of the state. In India, that is the Union Parliament. The Constitution of India lays down that the Union Parliament can pass laws on the subjects listed in the Union list and the concurrent list. The state government can pass laws only on the subjects in the state list. In addition, Union Parliament can legislate on the subject which is not listed in any of the three lists. Yes, in our constitution there are three lists on which the governments are to legislate. That is union list, state list and concurrent list. But if any subject is not in any of the three lists, that is called residuary power. That power automatically goes to the union government. Students, here I would like to inform you that Constitution was enforced in 1950, and that time there was no subject like information technology. So it was not in any of the three lists. But later, as the time passed and the need arose, as per the constitutional provisions, it was added in the concurrent list, and it is a residuary power which was not mentioned in any of the constitutional list. Now it automatically goes to the Union Parliament. Is it clear? Next comes a ordinance. An ordinance can be defined as a temporary rule of law which is needed at the time when Parliament is not in session. I told you already there are three sessions in a year, that is budget session, monsoon session and winter session. But this year, due to corona, there is only budget session was there, but we don't have monsoon session. Let's hope what happens in the winter session. An ordinance is issued by the head of the state for satisfying an urgent need for law. The ordinance thus issued immediately gets implemented as law. However, it can remain in operation for a specified period during which it is either converted into a regular law or it lapses after a fixed time. Already I have told you what is a fixed time. That is 6 weeks after the next session begins. Parliament can adopt or reject any ordinance. It is the Parliament's choice. Naturally, if the bill is sent by the ruling party, the Parliament will pass it because Parliament has majority with them. The bill is of ruling party. President has already introduced it through ordinance. So why the Parliament will reject it? It's very simple. Parliament will pass it. Already President has introduced it through ordinance, so it will pass. That's why it is called backdoor entry. The executive head of the state can issue ordinances, but this does not mean that he can rule by ordinances. Ordinance making power is an emergency arrangement. It cannot take place of law-making power of the Parliament. Students, now I will tell you an example. This year, farmers, especially from North India, recently staged a tractor march in Ludhiana to express their anger against rising fuel prices and three ordinances introduced by central government, namely the Farmers Produce Trade and Commerce Ordinance 2020, etc., all related with the farmers' production. Such ordinances were introduced in 2020. Fine. On the other hand, at the same time, Prime Minister Modi was speaking at the Ideas Summit on building a better future organized by US India Business Council, inviting American companies to come and invest in Atmanirbhar Bharat. The Prime Minister assured the agricultural reforms undertaken by the government would facilitate business and announced that the food processing industry is expected to be worth over $500 billion by 2025. These contrasting images of the tractor protest and the Prime Minister inviting American companies to come and invest in India after issuing ordinances tell a tale of power and its consequences. The government's power, which is trickling down individual farmers' life. The power balance is not with farmer but with multinational companies. This is how power of ordinance making is misused in India. Is it clear? That's why I was telling it is backdoor entry. Now, next is international law. International law is that body of law which relates to the behavior, actions, and interactions of the states at international level. Since all the states are sovereign states and no law can be imposed on them, international law is a system of law among the states and not above the states. It does not enjoy any legal sanction and it is not backed by force. The states obey the rules of international law because these are deemed essential and useful for the conduct of relations among nations. You know, students, today is the time of global world and all believe in international relations. So they all believe in international law. Is it clear? So that's why it covers the relations between the nations and includes fields such as treaty law, law of sea, international law, international human rights law, and refugee law. Students, according to the United Nations Law of Sea 1982, a country may claim an area extending 12 nautical miles from its coast to its own territorial sea. You know, a country can use that sea water for its own source. Additionally, it can exploit 200 nautical miles of the water column beyond its coast as its exclusive economic zone, that is EEZ. Here it means that no other country can enter in this water body without the permission of that country whose coastal area touches that sea. This is the international law of sea. Even one more interesting international law I would like to share with you. That is, no doubt, country means land area. But you know, the sky above India is also India. Yes, my dear students, no country can take its flight above India without India's permission. Even India also can't do the same without that country's permission. For international flights, there are permanent agreements between the governments. So there is no problem to the pilots. So this is a relevance of international law. Even the United Nations Court, that is International Court of Justice, decides the cases according to international law. So this is the relevance of international law. So students, this finishes the discussion of my today's topic. Now I will discuss topic related short questions. First question is, how did customs become part of state law? How did religion get a base in state law? Under delegated legislation, who is delegated the power to legislate and when? What are the kinds of law? What is the relevance of constitutional law? Name the body that legislates at national level and the one who legislates on the subject not mentioned in constitution. What is ordinance? How is this power misused? What is international law? Why do nations need it? And the long questions are, explain the kinds and sources of law. What is law? Discuss the nature and kinds of law. Students, it covers your pages from 139 to 143. Students, this finishes the chapter on law. Next time, I will discuss the next chapter. You will watch the video again and do the snap homework questions. Till then, goodbye.